threaten properties of theatre owners or viewing audience with it is the plain duty of the state to ensure speech is not silenced by the fear of the mob. Unless we read a positive obligation on the state to create and maintain conditions in which freedoms are guaranteed by the Constitution, there is a real danger that art and literature would become victims of intolerance. So, my lord, the state says if somebody wears a headscarf, there will be galata. Therefore, we are stopping everything. Can't be the reasoning, my lord. My lords, I will not trouble your lordships with more judgments. If your lordships can just have my written arguments, I'll just finish in 10 minutes, my lord. I have quoted everything. Just have a look at, my lord. My lords, the judgments which I cited, my lord, of Ghulam Abbas and Justice Chandrachud's judgment, my lord, in this indelibly 2020, according to me, my lord, give judicial recognition to the American doctrine of Heckler's veto. Lordships may make a note of that. Heckler's veto is this, my lord, that I go on the street, I want to exercise my freedom. Somebody comes and doesn't like Devdutt Kamat's face and says, threatens me, how are you coming to the street? State says that, look here, yes, Devdutt Kamat cannot go on the street because somebody else doesn't like, it may create trouble. So courts have taken the view, a heckler cannot be allowed to veto a fundamental right. And that's the Heckler's veto doctrine. And according to me, my lords, Ghulam Abbas Ali and Justice Chandrachud have in India recognized that doctrine. And therefore they say that there has to be a positive obligation on the part of the state to create a situation for enforcement of fundamental freedoms. And those Heckler's veto judgments, my lord, lordships will just make a note in my written note, page 14, my lords, para 30, 31 and 32. Three US Supreme Court judgments I have cited, which I will not repeat, my lord. Just make a note, para 30, my lord. Para 30 is one judgment, 31, 32, 15 to 16, my lord. 14, 15, 16. Then lordships kindly come to para 17, page 17, my lord. Lords, page 17, my lord, one of the arguments is, and that your lordships also, my lord, that order which your lordships passed on last Thursday, that nobody shall disclose any religious symbols. Lord, in our secular state, probably what your lordships had in mind, that nobody should display religious symbols. And that's what the state says. But our secularism, my lord, is not, my lord, Turkey secularism. Our secularism is positive secularism, where, my lord, the state plays an enabler role for the exercise of fundamental rights, religious freedoms of all communities. We recognize all religions as true. And that is what, my lord, I have explained at page 17, para 36. Justice Shah's judgment, my lord, in Aruna Roy. Lordships have page 17, my lords, of my written note. Yes. Para 36. The Indian interpretation of secularism stems from the Vedic percept of Sarva Dharma Samabhava. In this regard, attention is invited to Aruna Roy and kindly see, my lord, the quoted portion in para 8. I'm sorry, my lord. Yes.
Page 13.
1-3.
In our
page 1-3.
Written submission, it is on page 13. Para 36.
Yeah, I'm sorry, my lord. I'm sorry. Para 36, my lord. I think there is some page numbering problem. I'm so sorry, my learned friend. It's my mistake, my lord. Para 36, my lord. My lords, para 36 of Aruna Roy is quoted. And if your lordships have the the highlighted portion, secularism, therefore, is susceptible to a positive meaning, that is developing understanding and respect towards different religion. The essence of secularism is non-discrimination of people by the state on the basis of religious differences. Secularism can be practiced by adopting a complete neutral approach or by a positive approach, by making one section of religious people to understand and respect the religion and faith of another person. Based on such mutual understanding and respect for each other's religious faith, mutual distrust and intolerance can be eliminated. Notice what I am submitting is this. The state says that we are a secular state. We are not Turkey, my lords, where there is, my lord, negative secularism, where the state says that nobody shall display religious identity in public. That hijab ban was upheld, my lord, by that Turkish court, went to the European court, which was upheld. But their constitution is completely different. Our constitution is positive secularism, where, my lords, if we practice different faiths, that has to be recognized, that religious identities have to be recognized. Then, my lord, I have enumerated that I finished 25, my lord. I am saying that let's leave aside 25. Now, this is an innocuous practice of wearing a headscarf and not changing my uniform. And I say, my lord, this is a facet of the freedom of speech and expression. A reasonable restriction would be, my lord, that everybody wears a uniform, no difficulty. But a small exemption, if it is given of wearing a headscarf, Lord, I would say, my lord, that is in line with expressing that freedom. And that's what the Supreme Court said, my lord, that personal appearance, where I've cited that case in para 37, my lord, where I've said that freedom of appearance is part and parcel of Article 19(1)(a). And similarly, my lord, in paragraph 38, I have put it on the anvil of Article 21. I will not repeat, my lord. Puttaswamy judgment I have cited. And lastly, my lord, I have also put it on the ground of, my lord, Article 29. Because Muslims, my lord, will be protected under Article 29, being a religious minority, my lord, and at 29(2) as a cultural minority. And then, my lord, paragraph 44 onwards, that may really not arise for consideration in view of the others. Now, that was a situation before the learned single judge, where, my lord, these students were made to sit separately. And the question was, my lord, whether that violates Article 14. My lord, there I have said, my lord, that the segregation business, where putting Muslim students separately, wearing Hindu students separately, my lord, wearing hijab separately, that is completely destructive of our right to equality. That I have placed all those judgments also. And the last one, my lord, which I want to cite, last proposition, my lord, para 52. Mr. Heckler has argued this, my lord, that I say that on the provisions of the Education Act, my lord, there is no power, lords, of the state to prescribe or to have this GO. And I have cited section 7, my lord. Section 7 is for prescription of syllabi, etc. My lords, the argument which I want to make on this Education Act is this. And please, my lord, this is a demurrer argument. The demurrer argument is this. Assuming you have the power to enforce a uniform, assuming that Muslim students, my lord, wearing a hijab cannot be given an exemption, then I ask, my lord, where is the power to expel students from a school because they are not prescribing to that uniform? I can understand, my lords, people are wearing different uniforms, a disciplinary code. Wearing an extra, my lord, attire in the form of a hijab, and the school expels them. I submit, my lord, the doctrine of proportionality will come in. The lordship will have to examine this. This is not a case, my lord, where a student goes and fights with somebody and you expel him from a school or suspend him from a school. He is just asserting his religious rights under 25 and other fundamental rights, and you say that look here, there is a uniform policy, there is an act which says that rule 11 says that there is a uniform, and therefore if you don't wear a uniform, I'll expel you. But expulsion has severe consequence in administrative law. Lordships are very well aware. I don't need to cite judgments. Doctrine of proportionality will come in, and therefore, my lords, I end.
In your case, the students have been expelled.
No, my lords, I am saying they are not allowed to come. It has the same effect.
Different.
Students not being permitted to attend class.
Not Mr. Kamath, but Honorable Chief Justice. Honorable Chief Justice.
They are not expelled.
Expulsion is one thing. Not permitting to gain entry to the institution is another.
Absolutely. My case is the second. That institution.
Doctrine of proportionality, when in case they have not been expelled, how you are applying the doctrine of proportionality?
I am grateful for that question.
If a passenger is not permitted, 1 second, Mr. Kamath. If a passenger is not permitted to gain entry to a train because he does not have a ticket, that's not a case of expulsion.
I board on. Lords, it's my mistake. I used the wrong word. Lords, I'm sorry. I used the wrong word. They have not been permitted to come inside. And this is not a case, my lord. This is not a case, with greatest of respect, of a my lord's passenger alighting a train. My lord, this is a case where a student, apart from other fundamental rights, my lords, 14, 19, 21, 25, 29, is wanting to access education, which is also a fundamental right under 21. And the state says, my lord, that we will not permit you inside the school. And in that context, my lord, I raise the doctrine of proportionality. Is the action of the state proportionate to what? That's the
suggestion. Whether the has not been allowed inside the class or inside the school.
Inside the classroom. Yes, my lord. I am saying either which way, either inside the classroom or school, both have the same, my lord, legal consequences. Now, in that context, my lord, I end with this, my lord. Just have a look at your lordship's order, which your lordships passed, my lord. The detailed order which your lordships passed on Thursday. Probably, my lord, we are not in a position to assist your lordships that because of paucity of time and certain observations here, my lord. I respectfully submit.
By that order, nothing was decided.
Nothing was decided. Whatever your lordship say, my lord, whatever
was also decided.
Hold on, my lord. Whatever your lordship says, my lord, as a constitutional court, my lord, has great significance, has great value, my lord, to citizens of this country. Now, kindly see paragraph 8. Firstly, we are pained by the ongoing agitations and closure of educational institutions since the past few days, especially when this court is seized of this matter, and important issues of constitutional significance and personal laws are seriously being debated. Absolutely correct. No? It hardly needs to be mentioned that ours is a country of plural cultures, religions, and languages. Being a secular state, it does not identify with any religion of its own. Every citizen has a right to profess and practice any faith of choice is true. However, such a right, not being absolute, is susceptible to reasonable restrictions. Now, lords, this in my respectful submission is against the Constitution. Why I say this, my lord? Because Article 25, there is no concept of reasonable restriction, my lord. Article 25 is subject only to public order, morality, and health, my lords. Number one.
Those are the restrictions.
Do you say that there are restrictions?
I'm making a submission. Lordships may want to, my lords, have a different view. According to me, my lord, this reasonable restriction.
Pointed out how the article starts.
Subject to.
Yes,
subject.
Yes. Then lastly, my lord, just have a look at the operative portion. Pending consideration of these petitions, we restrain all students, regardless of their religion or faith, from wearing saffron shawls, scarves, hijab, religious flags, or like within the classroom until further orders. I respectfully submit, my lord, the sweep of your lordship's order is, my lord, extremely broad. But I say that it is in the teeth of Article 25, my lords, and also other constitutional rights. And my lords, kindly make some leeway. Lordships are examining, my lord, issues of, my lords, grave constitutional significance of seminal importance. In the meanwhile, my lords, please permit us to, my lord, carry out this innocent faith, subject to whatever conditions your lordships may impose. We will have the same, my lords, uniform. We will, my lords, just wear an additional headscarf, because this consideration is going to take time, my lords. My learned friends, my lord, you lordships will have the benefit of erudite, my lord, submissions. The best counsels, my lord, are going to assist your lordships. So therefore, my lord, I respectfully submit this order, in fact, my lord, suspends fundamental rights. Please don't, my lords, continue this order from today, my lord, is my respectful submission. Lords, I bow down to your lordships for having heard me patiently, my lords. And I part, my lord, by also, my lord, mentioning that my friends, my lord, Nishant Patil, Nizam Pasha, my lord, and Shahul and Niyas have contributed immensely to the research, my lord, which has been placed before your lordships. And I am only the mouthpiece of their hard work, my lord. I'm grateful for a very patient hearing, my lord. Grateful, my lord.
Thank you.
Lords,
I am also making one submission with my lord's permission, my lord.
Item number 1, that is 2347, in continuation with what has already been submitted. I think, Lord, I believe that I stand in front of the law which your lordship designed yesterday.
You are in which case? 2347?
Yes, 2347. The next impleading petition in support of
My lord, may I kindly
I will submit is this. I won't be taking time. I will be shortening myself by making a proposition. This is my point, my lord.
With respect, may I make the submission? I am appearing for the petitioners in writ petition 2347.
2347, already submissions have been made by Mr. Kamath.
Sanjay Hegde.
Like 2347.
My lord, I appeared, my lord, in the first petition, my lord.
2347 has not been argued, if I may say so.
Mr. Sanjay Hegde submitted in 2146.
No. My lords, I appear in my lords 2146, my lords, which is the first petition in the line of the order.
1.1 is.
My lords, in fact, the 6 petitioners, these are the first 6 girls.
Just let us first understand who is appearing in which case.
My lords, the first petition which was filed before the honorable single
Wait
judge.
for some time, Mr. Mir, please wait. 1.1.
1.1 argued by Mr. Sanjay Hegde.
2146.
2146.
Mr. Sanjay Hegde.
1.2 WP.
Just a minute. 1.2.
1.2, that is WP 2880 or 22. 2880. 22. Today, Mr. Devadat
This has been argued. Yes, Mr. Kumar. Mr. Kumar.
Please,
Yes.
may I request the court to kindly.
You want to appear in 2347?
Yes, 2347, I appear.
All right. Give the
Please.
file.
I am also appearing, my lord. I am joining to a lordship, my lord. Early in the morning, I also gave your lordship trouble, but that was not a proper bench. A.M. Dar, senior advocate from Delhi, my lord. I have filed a fresh petition, that is 3418. 3418. Early in the morning, I filed that petition, subject to your lordship's approval, permission, anytime, my lord. Whenever lordship would feel convenient, can also hear me that fresh matter, my lord. 3418.
All right.
I am grateful.
347. Yes, Mr. Kumar.
Yes, may I request the court to kindly take the statement of objections filed by the state. They have filed a common.
No, I just want to point out something factually, my lords. If my lords are to see the petition which Professor Ravi Varma Kumar is now arguing, that is WP 23447 of 2022.
Yes.
The petitioner is one Srimati Resham. Kumari it has to be.
Yes, Srimati Resham.
Now, my lord, this very petitioner had filed has filed in fact 2146 of 2022, in which Mr. Sanjay Hegde has argued.
She has filed 2 petitions.
She is one among the 5 petitioners. Petitioner number 2 in 2146 of 2022. One shall just complete 2146 of 2022. Petitioner number 2.
2146.
It's the same person.
Yes.
So they are the same persons, but they may have to justify, either withdraw one of the petitions. And they have been argued at length by Mr. Sanjay Hegde and so forth.
Yes.
Because if my learned friend is arguing on questions of law, I don't have any objection, but I must point out that this second petition will not be maintained.
In this petition, 2347, there are 2 petitioners. 2 petitioners. One is Srimati Resham, the other is Sri Mubarak.
No, that is not through next friend, Mubarak. She is 17 years, so therefore she is represented through Mr. Mubarak.
Petition is the petition number 2, Lordship. The moment I came to know about this fact, I filed a withdrawal memo in respect of petition number 2, Lordship. It's also there on the record.
Which petition?
2146, Lordship.
21.
In respect of petition number 2, already I filed a withdrawal memo on the very same day, Lordship.
2146, you have moved a withdrawal.
Withdrawal in respect of petition number 2, who is the none other than the petitioner in another petition. So that controversy is not required.
That has not been allowed.
We already in the record for the very first day, and the learned judge said that, honorable judge said that it has to be close together, and we'll consider it. The memo is there on the very first day, and it is in the record. Even I got in the notice of the court also, the same day.
No, the point is, my lords. No. The point is this: on behalf of Resham, arguments, the questions of law and facts, arguments have been addressed. If they want to assist your lordship, this is different. But the same petitioner cannot urge the same questions of law on fact, based on same facts again and again through another counsel. That is what I want to point out. That is question of duplication of efforts and saving the precious time of the court. But this is not this to the learned senior counsel who wants to address some questions.
We are arguing on that day on respect of preliminary prayer. Interim prayer only is argued on that.
No, he made a statement that he wants to argue finally. Before us.
We
asked him whether he wants to make submission on the interim relief, or finally he said we want to argue finally.
Interim relief, he was arguing on interim relief. Several points he has not raised it. Now, Mr. Tanvir is going to continue the argument from that. There will no duplication on the front.
No, sorry, mister. This way will not allow. This way will not allow. Mr. Hegde has made his submissions. We have noted it. And he made it.
May I most respectfully, my lords, make a mention? My lords, Mr. Hegde, my lords, made his submissions at the prima facie stage in 2146.
Where are you? Yes.
Mr. Tanvir is working here.
My lords, I'm from my chambers at New Delhi, my lord.
Yes.
Now, my lords, thereafter, my lords, I was, my lords, instructed.
You said you will appear in a fresh case which you have filed today. We will hear you.
That I have filed. I have filed one.
My lords, I am for the original petitioners, my lords, in the line of chronology. 2146, my lords, is the first petition.
2146.
Mr. Mir should wait. Mr. Mir should wait when the senior advocates, my lord, would address. They have the privilege, my lord, that your lordships have been permitting the seniors so that they will, my lord, put across the constitutional points. Mr. Mir should wait, my lord. He has been disturbing.
I don't think, my lords, my legal friend should, my lords, even speak.
Please
I'm
wait.
making a submission to the honorable court. I don't know.
Yes, that's why we are saying.
Now,
I
my lords,
filed
this
a
is
fresh petition early in the morning.
On the first day, You people cannot decide as to who is to argue first.
Please, Your Lordship. It is only the Honorable Court. That's correct.
And let us one thing be very clear, that we will hear only one counsel in one case.
Absolutely correct. Your Lordship is right.
My lords, as far as 2146 is concerned, my lords, at this stage of final hearing, my lords, I would like to make some submissions.
Mr. Sanjay Hegde has already made his submission in 2146. Now we will not permit any other counsel to argue on that.
Not an issue, my lords, then allow us to, my lords, file a written submission.
Written submission he has already submitted.
My lords, that was, my lords, at this stage of preliminary. My lords, initial argument leading to an interim order. My lords, as your lordships have heard Mr. Kamath, my lords, finally in the matters, we have also done some research which we find, my lords, will be of great importance to this honorable court.
Please don't waste time of the court. Let's say hear the other counsels. Yes, Mr. Ravi Kumar Verma. Ravi Verma Kumar.
My lords, we have submissions in addition to this, my lords, if your lordships permit.
He has been disturbing always,
my lord.
Is the audacity ought to disturb everything, well.
May I request the court to kindly permit me to show from the statement of objections?
Yes.
What is the source of which the government has exercised? They are very succinctly set out.
Mr. Ravi Verma Kumar, let's first understand the status of this petitioner. This petitioner has filed another writ petition in which he has filed a memo for withdrawal.
Yes, I respectfully agree that there cannot be two petitions by the same petitioner.
He is not pressing that writ petition. Now she wants this matter to be argued by you.
Yes. She wants to withdraw the other petition that was filed along with a batch of students.
All right, then in that petition we will allow the memo for withdrawal.
Yes, that may kindly be. I am grateful.
And you argue on behalf of the petitioner in this petition.
Yes.
Yes.
May I request the court to kindly permit me to point out paragraph 12 of the statement of objections. This is the sheet anchor of the respondents case as to why they have prevented the students from entering the school, college.
This would be allowed on behalf of. This is to be allowed. No? No,
That memo is in fact listed before the court today. It is shown in the cause list.
2, 3, 4.
Shown in the cause list.
Statement of objection is filed in this matter, but petition is argued. This petition is being argued. The petition.
This statement of objection is not there.
It is not filed in that matter. It is filed in the
Mr. Ravi Verma.
Please.
Statement of objection is not there in 2347.
It is a common statement of objections filed in 2146 of 2022 connected with 2347.
Yes.
Kindly see the maybe I don't know whether they are not they
Yes.
are.
All right. Yes, a statement of objection is there in 234.
Please kindly come to page 15. Para 12.
Yes.
It is submitted that respondent 5 institution has followed the Karnataka Education Act 1983, the Karnataka Education Institutions Classification, Regulation and Prescription of Curricula, etc. Rules 1995, referred to above, and directed the students, kindly mark this, directed the students to follow the uniform dress code in the college campus and classrooms. The long-standing practice of this uniform system is a settled fact, accepted and admitted by the College Development Committee under the chairmanship of local MLA and other office bearers have discussed the subject on 31/1/2022. Kindly mark the date. I was prevented from entering the class or the school 3 days prior to 31st. On 28th, I was prevented from attending the classes. So they are banking upon the decision taken on 31-1 in the presence of some of the petitioners and their parents. The request of the petitioners was discussed at length. After analyzing the law, public order, and notions of secularism, kindly mark it, who are doing this? Notions of secularism, equality, and conflicting interest. It was decided that the existing uniform system shall continue. The students in the petitioners cannot be allowed to wear hijab inside the premises of the institution, and if they violate the dress code and wear hijab, such act shall amount to violation of code of conduct of the institution and be considered as a subject matter of disciplinary action. Kindly mark this as a code of conduct of the institution. Kindly mark it. I will show for a moment there is no such code of conduct. It was made clear that strict action shall be taken against such indiscipline, and thus students were requested to follow the discipline and uniform dress code prescribed by the college. Copy of the resolution dated 25/1/2022, 31/1/2022, produced as Annexure R3 and R4 respectively. Para 13. It is submitted that the state government, in exercise of its power of superintendence and control over the institution under the Karnataka Education Act, issued directions on 25/1/2022 that the government is examining, kindly mark it, that the government is examining the larger issues of dress code and uniform system up to PU level, and there are conflicting views and interests in the subject, and in view of the sensitivity involved in the matter, a high-level committee is being formed to examine and report back with the recommendation to the government. In the meanwhile, it was also directed that respondent number 5 college shall continue with the existing uniform dress code till a comprehensive policy or decision is taken on the subject. The said direction of the government taken on 25/1/2022 and of the above proceedings of the College Development Committee on 31/1/2022 has been specifically communicated to the students through instructions dated 1/2/2022 by registered post. Copy of the directions are produced as R5 and R6. So kindly mark it. The government is yet to take a decision. It is constituting a high-level committee which is going to look into the matter, and only after that deliberation is over and a final decision is taken. As of now, government has not prescribed any uniform. Government has not prohibited wearing the hijab. Now kindly see para 19. Para 19 at page 29.
Para 19.
Para 19, 19, page 29.
Yes.
It is pertinent that the government of Karnataka, exercising its power under section 7(1)(I), 7(2)(g)(v), read with section 133 of the Karnataka Education Act 1983 and Rule 11 of the Karnataka Education Institutions Classification, Regulation and Prescription of Curricula, etc. Rules 1995, has issued Government Order dated 4/2/2022 regarding uniform policy for educational institutions in the state. Kindly mark, there is no prohibition for wearing the hijab here also. The said notification has been issued having regard to the conflicting views, demands by various educational institutions and students at large. After rising of the issue involved in these petitions, the students of various institutions of state of Karnataka have started insisting of clothes to be worn to their choice, they are seeking for relaxation and exemption from following uniform dress code prescribed by various institutions governed under the Act. In order to resolve the controversy, the government thought it appropriate to prescribe uniform dress code by virtue of the order dated 4/2/2022. Copy of the order dated 4/2/2000 is Annexure R8. Let us see whether there is any prohibition for wearing hijab in Annexure R8.
Page number?
Page number 116, the Kannada version. The English translation has been handed over to the court. I do not want to go into the controversy of Suvyavaste. It is definitely Avyavaste. Kindly come to the operative portion of the order. I will not trouble the court with the preamble to the order. So certain assumptions are made, certain opinions are formed. Sir, the order starts at page 116, 116. It is in Kannada. The English version has been handed over to the court. There appears to be a typographical error in the statement of objections. The order is dated 5/2,
Not 4.
not 4.
Whether it is 4-2 or 5-2.
5/2. Order says it is 5/2.
5-2 we have got. Just
Impugned government order.
That is the
Stated as
impugned government order.
4-2, yes, impugned order. Impugned government order.
Is it 4-2 and
So
5-2?
if there is no 4-2, there's a mistake in the statement of object. It is 5-2.
Mistakes are not only in words, figures also.
Please.
Yes.
Kindly come to the operative portion of the order. Yeah. Just before that, what they have summed up may kindly be noted. As the Supreme Court and various high courts have held that restricting students from coming to school wearing headscarves or head covering is not in violation of Article 25 of the Constitution. And after carefully examining the rules under the Karnataka Education Act 1983, the government issues the following order. In exercise of the powers conferred under section 133(2) of the Karnataka Education Act 1983, we direct students of all government schools to wear the uniform fixed by the state. Students of private schools may wear uniforms prescribed by the management committees of the school. Kindly pause for a minute. Government itself has said they are yet to decide on the uniform. There is no uniform prescribed by the government. They are constituting a high power committee to go into that question. That issue is yet to be decided. In the meanwhile, they say school they should wear uniform fixed by the state. So as and when it is going to be fixed, it shall be taken note of. But as of now, this order is premature because no uniform has been prescribed. The students of private schools may wear uniforms prescribed by the managing committees of the school. In colleges that fall under the Karnataka Board of Pre-University Education, dress code prescribed by the College Development Committee, kindly mark it. Dress code prescribed by the College Development Committee or the Administrative Supervisory Committee must be followed. If the administration does not fix a dress code, clothes that do not threaten equality, unity, and public order must be worn. Kindly take note of the fact there is no ban of wearing hijab by any students, much less students of religious minorities belonging to Islamic community. It says the Development Committee will fix it. They will prescribe the dress code. Till then, clothes that do not threaten equality, unity, or public order must be worn. We are not violating equality. We are not violating unity. We are not violating any public order. Be that as it may, there is no order against hijab. That is the sum and substance of this thing. Now they have provided that the College Development Committee shall prescribe the uniform. May I request the court to take the Act, Karnataka Education Act. Sir, this is a complete code in itself. Entire aspect of education to the level of PU is covered by the Act.
You want to refer section 133?
No, I'll point out that this College Development Council is a non-existent body under this statute. It is an extra legal authority which is endowed with the power to prescribe the uniform, contrary to the scheme of the Act and the letter of the rules.
Yes.
May I request the court to kindly note down under section 2, the definition clause, all the authorities that are entitled to exercise power under the Act are specifically defined. Subsection 7 of section 2 may kindly be erased. Subsection 7 of section 2
Competent
defines
authority.
competent authority. It means any person, officer, or authority authorized by the state government by notification to perform the functions and discharge the duties of the competent authority under all or any of the provisions of this Act for such area or for such purposes or for such classes of institutions as may be specified in the notification. This is a competent authority, not endowed with any power to prescribe the uniform. And College Development Authority is not, Development Council is not. Then kindly come to the Managing Committee under subsection 19. Before that, Governing Council may be perused. Subsection 17. Governing Council
Yes.
Governing council means any person or body of persons permitted or deemed to be permitted under this act to establish or maintain a private educational institution. Kindly mark. Or a commerce institution. Or a tutorial institution. And includes the governing body by whatever name called, to which the affairs of the said educational institutions are entrusted. Sir, this is not a private college. It is not a tutorial institution. It is not even a commerce institution. Commerce institution is defined under subsection 9. Kindly permit me to show. Commerce institution means any institution imparting commerce education and presenting students for examination conducted by the Karnataka Secondary Education Examination Board, that is up to SSLC and below, like typewriting institutes. They are all called as commerce institutes. Anyway, it does not include a pre-university college. And then tutorial institute is also defined.
214, Professor.
Please.
214.
Yes, educational institution means any institution imparting education referred to in section 3 includes a private education institution, but does not include an institution under the direct management of the university or the central government or a tutorial institution.
All right. You say that the College Development Council is not defined in this definition. It is
not an authority under the provisions of the Act.
It is not a statutory body under the Act.
Not contrary.
We'll continue tomorrow.
Very well.
Please, Your Lordship.
In WP number 2146, 2022, has been concluded. The arguments in writ petition 2880 of 2022 have also been made by Mr. Devdutt Kamath. He has completed his arguments. Mr. Ravi Verma Kumar, senior advocate, is arguing in writ petition number 2347 of 2022. He is continuing with his arguments. Put up tomorrow at 2:30.
My petition is also clubbed with my Lord's permission. 3418. Be clubbed.
May I make one submission? The
3418.
opening
Withdrawal in that writ petition
1 second.
shall be stand allowed, and the petitioner in that writ petition shall the petition on behalf of petitioner shall stand dismissed as withdrawn. Yes.
May I make one submission? The colleges are reopening tomorrow.
Yes.
I therefore fully submit that the application I had made yesterday.
That application is same defective. It does not have a verifying affidavit by the party. It is by the council minutes on record based on his own knowledge. Lordship, we can't respond. Anyway, I have my submissions to be made on that.
Lordship, may I make one submission, Lordship?
1 second.
I filed this application, senior counsel has filed application in my petition, Lordship. And I have presented a memorandum of fact. And I have stated also reason for what reason I am presenting a memorandum of fact. Because petitioners, they're in Udupi. It's very difficult for them to come all the way to Bangalore to file a...
That way it is not maintainable.
Lordship, kindly appreciate, Lordship. There is also provision if the memorandum of fact can be supported.
Because under the Karnataka civil rules of practice, if my lords are to examine rule 17, 18, no, I'm just pointing out. Memorandum of facts can be sworn in by the counsel only in respect of matters which are on record. And these are all not serious allegations made. So, but kindly, permit me to.
If there is.
Before rising, my lord, that submission might be, my lord, 3418, maybe also clubbed.
It's also here. This rule we have adopted under Rule 37 of Proceeding Rule 77. Civil rules specifically mention the situation when the counsel can present a memorandum of fact, lordship. These things are there in the civil rule. Relying on the same position, I have furnished my memorandum of fact along with my application, lordship. And I have specifically mentioned the reason for what reason they are not able to furnish affidavit. In their absence, with their consent and permission, I presented a memorandum of fact along with the application, lordship. So I cannot be prevented from that application, lordship.
A bad practice. This is
not rules are there.
Practice. This is not a correct practice. Application has to be accompanied by an affidavit, which is to be sworn by the petitioner or his authorized parocar. A lawyer cannot be authorized parocar.
Lordship,
so we will not allow this bad practice to begin with. A lawyer cannot be permitted to sworn an affidavit.
May I make one submission, lordship, in this regard, lordship? Lordship, there is kindly peruse the civil rules, lordship. There is only 5 occasions was provided on which affidavit is necessary.
We will reject the affidavit.
Affidavit necessary, and all other occasions, memorandum of fact also can be furnished along with the application. The parocar system is not there in the South India, lordship.
Advocate is rejected. We'll continue tomorrow at 2:30.
May make a submission, my lord. The statement of objection filed by the state is not served to the petitioners, my lords. Kindly direct the state to further copies of the statement.
Will copy. I do not know.
Before rising, my lord, one submission that my petition will be also colored, my lord, 3418. I shall be grateful, my lord.
Let it come before the court.
That is before the bench secretary, my lord. It's filed today early in the morning, my lord. Fresh petition.
Come today.
Please,
it will be listed along with that.
Please, grateful.
My lords, I am Dr. Vinod Kulkarni, party in person. I may be kindly heard tomorrow, my lords, for the same petition.